Morning, everybody. Welcome along to our May edition of our AHOLA Lunch and Learn webinar series. Today, navigating the increased ICE enforcement and looking at some expert I-9 compliance strategies. So today, we're going to be discussing the I-9 form, the rules surrounding its completion and retention, and then how to avoid those costly penalties for non-compliance. So before we start, I'd just like to remind you that we are not attorneys. This session is intended for educational and informational purposes only. We do hope you find these presentations helpful and informative, but the information presented today should not in any way be construed as legal advice. And as always, if you have any questions about how this information may affect your business specifically, then we recommend that you consult with your business advisor. So for those of you that don't know, AHOLA is a family-owned and payroll and HR services provider. We're headquartered here in Brecksville, Ohio. We have over 50 years of payroll, tax, and HR experience and have served over 10,000 small businesses throughout the nation. And we offer a full range of payroll and HR services as well as software. My name is Alex Brown. I'm one of the learning and development specialists here at the AHOLA Corporation. I've been with the company for about 2 years, and I have been in the corporate training environment for 15 years with various companies throughout Northeast Ohio and nationwide. My focus with AHOLA is with our new client and existing client trainings, and I deliver weekly trainings on those platforms within ISOLT that they purchase from us. So before we start today's webinar, I'd like to just say a special thanks to my colleague, Lori Geiger. Lori is part of AHOLA's Proactive HR Consulting Division and has put together the content for this presentation today. Lori has been with AHOLA for about 3.5 years and enjoys working with those small business clients in several diverse industries, including light manufacturing and business services. Prior to AHOLA, Lori earned her bachelor's degree and maintains her professional and human resources certification, accredited by the HRCI, and is especially passionate about bringing HR consulting clients up to date with compliance topics that mitigate their risk for legal issues. Lori is also a very strong advocate for compliance with maintenance of the I-9 form. And we hope that you find this presentation insightful. So I just want to give a shout out to Lori for providing us with the information today. As we go through today, if you have any questions, you can type those in the question and answer or in the chat. I will be forwarding those to our proactive department, and then they'll be reaching out with the answers to those questions for you. So today we are going to look at the I-9 form and the basic requirements and general practices on its completion. We'll also be reviewing how to conduct internal reviews and rectifying any errors on the form, how to avoid those common mistakes, including avoiding discriminative and human error mistakes on the form, and then discussing the potential penalties that are associated with the I-9 and I-9 audits. So what is the purpose of the Form I-9? So federal law requires employers to verify the identity and employment authorization of new employees, and in certain instances, to re-verify that the employee is still authorized to work in the US. So let's dive deeper into its significance. There are two enforcement agencies who police I-9 compliance and regularly conduct audits. They are the Department of Homeland Security, or DHS, and their primary responsibility is to protect the nation's land, sea, and air borders from illegal activity when they facilitate lawful travel and also trade. And then we have the Immigration and Customs Enforcement, more commonly known as ICE, and they are a federal law enforcement agency under the direction of the Department of Homeland Security. And the responsibility of this organization is to protect the US from cross-border crime and illegal immigration that may threaten national security. They are also responsible for conducting I-9 audits and issue those penalties for non-compliance. So the purpose of the I-9 form comes under the Immigration Reform and Control Act and requires all U.S. employers to complete a Form I-9 verifying the eligibility to work in the U.S. for every employee hired after November the 6th, 1986. All U.S. employers, regardless of size, must comply with the Form I-9 requirements. So let's look at completing the Form I-9 Section 1. Employees must complete Section 1 of the Form I-9 on the first day of employment and must present acceptable documents proving identity and work authorization to the employer within 3 days of the first day of employment. In Section 2, employers or their representative must physically examine those documents and complete Section 2 of the Form I-9 again within 3 days of the employee's first day of employment. Unless the company is an E-Verify company, and V-Verify employers can now remotely examine those Form I-9 documents. The Supplement A is used only when a preparer or a translator is used in the assistance of completion of Section 1, and Supplement B is used only for when rehiring or for re-verification. That was formerly known as the Section 3 on the I-9. The acceptable documents that the employee must show his or her employer is a document from List A, which shows both the identity and employment authorization, or one document from List B, which shows identity, and one document from List C, which shows employment authorization, or an acceptable receipt of those documents. So some basic requirements and best practices regarding that form. Make sure you're always using the latest version of the form, and make sure that all the information that you put on that form is clear and can be read. Check the date that you enter in Section 2 as the date employment began, and make sure that matches the employee's payroll records. And then also, when you examine the I-9, make sure you know and you actually examine it accurately, making sure all the information is correct. And you also understand the record retention for the I-9. Prepare for an audit, even if you think you are compliant, and understand the E-Verify rules. And the big thing is prevent the preventable. So checking that form over will help you with that situation. If the employee is rehired within 3 years from the date his or her previous I-9 was completed, the employer may either update the existing form, or you can in fact complete a new one. For re-verification, the employers must re-verify an employee's employment authorization no later than the date on the employment authorization expiration. And certain documents that show permanent work authorization do not need to be re-verified. If you're using electronic forms, you are permitted to use these, and you can utilize an electronic version of the Form I-9, and also you can obtain electronic signatures. Those I-9 forms should be retained for 3 years after the date of hire, or 1 year after the date employment ends, whichever is the later. Employers may choose to scan and upload an original of the signed I-9 form and store them electronically. The E-Verify allows participating employers to electronically verify the employment eligibility of their newly hired employees. So let's take a closer look at Section 1 of the I-9 and some of the common mistakes that you can avoid. In Section 1, the employee does not enter name other than last names used, such as maiden name, the address, or date of birth. Employee does not enter his A number, a USCIS number after selecting a lawful permanent resident, or enter the same number on the Form I I-94 admission number after selecting that they are a non-citizen. Employee does not sign or date the attestation. The employee does not complete Section 1 by the first day of employment, date of hire, meaning the commencement of employment for wages or other remuneration. Another common mistake to avoid is the employee does not check one of the boxes indicating that he or she is a citizen or non-citizen national of the US, a lawful permanent resident, or a non-citizen authorized to work until a specified date, or indeed checks multiple boxes attesting to more than one of those above situations. Another mistake is the preparer or translator for the employee does not complete Supplement A, which is the preparer or translator certification for Section 1. Another mistake to avoid is each preparer and or translator for the employee, if more than one is used, does not complete separate preparer or translator certification areas. So if more than one person is helping the employee to fill out the form, then there has to be 2 certifications for each of those persons who helped with the form preparation. Another mistake is the preparer or translator for the employee does not enter his or her name, address, or signature in the relevant certification box. And please be advised that there is a certain order in which the name has to appear in those boxes. And also that the preparer or translator for the employee does not enter a date in the certification box also. So that is the main parts and the common mistakes that we find in Section 1 form, Section 1 of the I-9. In Section 2 of the I-9, this details applicable verification documentation that has to be produced by the employee for verification. Some of the common mistakes to avoid in Section 2 is that the employer does not enter an acceptable List A document or acceptable List B and C documents on the form. Or the employee does not enter the document title, issuing authority, its relevant number, or its expiration date for the document is presented. Maybe the employee does not enter its business title, name, or address, and again in the order in which it states on the form. The employee does not enter the date the employment began or the date of hire, or the employer or employer's authorized representative does not sign, date, or enter his or her title, last name, and first name in the certification. And the employer does not complete Section 2 by the 3rd business day after the date the employee began employment, or if the employee is hired for 3 business days or less at the time the employee started employment. So that does have a time constraint on that form to be completed and verified by the representative of the company. Supplement B to the I-9, or as it used to be called Section 3, some of the common mistakes to avoid in this form or this part of the form is that the employer does not enter the employee's name, the employee's last name, first name, and middle initial in that order in the employee name from the Section 1, and it matches the top part of the page. The employer does not enter the document title, number of expiration date for the acceptable document that is presented, or the employee does not enter the date of rehire. If the employee has a new name, the employer does not enter that employee's new name in the relevant box, and the employer does not sign, date, or enter his or her name in the certification box. And the last thing about some of the mistakes we see on the Supplement B is the employer does not complete Supplement B until after the employee's work authorization has expired. So moving on to preventing discrimination in the Form I-9 and looking at the E-Verify process. So employers cannot base on an individual's citizenship, immigration status, or national origin. The employer cannot ask to see employment authorization documents before an individual accepts a job offer. The employer may refuse to accept a document or refuse to hire an individual because a document will expire in the future. And the employer refuses an accreditable receipt. The employer may also request a specific document for I-9 or request specific documents to create an E-Verify case or based on an E-Verify tentative non-confirmation. The Immigration Reform and Control Act, enacted in November 1986, requires employers to verify the identity and employment eligibility of their employees and also sets forth criminal and civil sanctions for employment-related violations. The administrative inspection process is initiated with the service of a Notice of Inspection, or an NOI, upon the employer. Employers receive at least 3 business days to produce any Form I-9 when requested in the NOI. In addition, ICE generally requests that the employer provide supporting documentation, which may include, but is not limited to, a copy of the employer's payroll, a list of active and terminated employees, articles of incorporation, and business licenses. When an employer responds to an NOI by producing Forms I-9, ICE agents and or their auditors will then go ahead and conduct an inspection of the Forms I-9 for compliance. When ICE finds technical or procedural violations, the employer receives at least 10 business days to make any corrections deemed necessary. An employer may receive a monetary fine for all substantive and uncorrected technical violations. Employers who are found to have knowingly hired or continued to employ unauthorized workers will be required to cease the unlawful activity and may be civilly fined and or criminally prosecuted. Additionally, an employer who is found to have knowingly hired or continue to employ unauthorized workers may be subject to debarment from ICE. Upon completion, in its inspection of an employee Forms I-9 and any relating supporting documentation, ICE will notify the employer of its findings in writing by issuing one of the following notices: a notice of inspection results, notice of suspect documents, notice of discrepancies, a notice of technical or procedural failures, a warning notice, or a notice of intent to fine, or that commonly known as an NIF. In 2025, I-9 paperwork violations carry fines ranging from $288 to $2,861 per Form I-9. For knowingly employing unauthorized workers, penalties for the first offense range from $716 to $5,724, while second offenses range from $5,724 to $14,308, and subsequent offenses can range from $8,586 to $28,619 per worker. So I-9 paperwork violations, those fines range from $288 to $2,861 per Form I-9 for those substantive violations or uncorrected technical errors. Knowingly employing unauthorized workers, the first offense, those penalties are $716 to $5,724 per worker. Knowingly employing unauthorized workers on a second offense, those fines range from $5,724 to $14,308 per worker. Knowingly employing unauthorized workers for a third or subsequent offense, those penalties range from $8,586 to $28,619 per worker. And for E-Verify employers, the failure to inform the DHS of continuing employment following a final non-confirmation, those penalties range from $973 to $1,942 per employee. There are some factors affecting these penalties. They look at the size of the business. The size of the employer's business is a factor when considering the determination of the penalty amount. The good faith of the employer. ICE considers the employer's good faith efforts to comply with I-9 requirements. They look at the seriousness of the violation, and the severity of the violation is a factor in determining the amount of the penalty. The involvement of unauthorized workers. So they'll look at the number of unauthorized workers involved in the violation. And then the history of previous violations. Does the company have a history of previous I-9 violations? And if they do, that can result in higher penalties. So just an additional note, the Department of Homeland Security adjusted these penalties for inflation and published the revised amounts in the Federal Registry on January the 2nd, 2025. So look at a checklist for surviving an I-9 audit and what you need to do. So collate all forms I-9. Employers need to check and ensure that there is an I-9 on file for each and every employee currently working for you in the US. You should also have a list of current employees that you do not have a form I-9 for. If you have any I-9s for non-employees that do work for your organization, for instance, volunteers or consultants, you should remove them from your file. Next, you are going to prioritize the I-9s. The highest priority are current employees that have no form I-9, as these possess the great risk to you, and you need to verify their eligibility to work in the US immediately. The next priority is to review current employees' I-9s to make sure they've been completed thoroughly and properly. And finally, you should review the terminated employees' I-9s also. All employees hired on or after November the 6th, 1986 should have an I-9 on file, as we previously mentioned. If they don't, they need to be contacted and instructed to provide proper documentation for completion. As an employer addressing these employees, you should apologize that the form was not collected at the beginning of employment. However, you need to explain that the form must be completed under federal law, and that failure to provide the necessary documentation may lead to their termination. Communicate with each employee individually, either verbal or written, and make sure to keep a copy of all that communication that goes between you and that employee for the Form I-9 audit file. You should establish a date when employees need to provide the required documents, and generally they should have to bring them to work the next day. The documents should be originals, and when necessary, documents are available. The Form I-9 should be completed immediately. Use current dates on the form, even if the date of hire was years ago. Attach a note to the corrected form explaining that the I-9 was completed during the audit. This is crucial as it shows that you made that effort to be in compliance and were not willfully breaking the law. Auditing your current employees. Employers can only correct technical errors in Section 2. Errors in Section 1 must be corrected by the employee. Separate your forms into two files, one of I-9s that were completed properly, and the second of those that contain errors. Any changes that you make on the I-9 should be clearly shown as a correction. Use a different colored ink. Draw a line through incorrect information and initial and date any changes to make sure that it is obvious. Major errors, such as entire sections left blank or based on unacceptable documents, may require a new Form I-9 to be completed. Review the errors. Make a list of I-9s that have errors. This forms part of the audit log. It should contain the employees' names, the errors, and the actions that were taken to correct those errors. And then organize and correct terminated employee I-9s. Determine if the Form I-9 retention period once an employee is terminated, and then correct any errors for terminated employees, and you would use the same process as you would for current employees. If you are unable to correct an error, such as a missing employee signature, make a note in the audit log and on a note on the appropriate Form I-9. So when you audit your current employees can only correct technical errors in sections 2, and errors in sections 1, again, must be fixed by the employee. Separate those forms into 2 files, ones that were completed properly and ones that contain errors. Any changes should be clearly shown as a correction. And again, use a different colored ink, draw a line through the incorrect information, and initial and date the changes to make sure it's obvious. Entire sections left blank or based on unacceptable documentation would require a new Form I-9 to be completed. And again, when you review those errors, make that list of the errors on an audit log, and that then forms part of your documentation. So if we tie this all together, as we've discussed, it is critical that US employers of all sizes have an I-9 form for all of their employees. Filling it out correctly and completely is sometimes tricky, so we always encourage our clients to do these self-audits. Government audits are on the rise, so it's best to be as prepared and as compliant as possible to avoid any penalties. We invite you to stay informed by visiting our blog at ahola.com blog and subscribing to our Proactive HR Inspire newsletter, a free bi-weekly email update where we always share trending HR topics, tips, and best practices for small businesses. So if you would like on that mailing list, please email proactivehr@ahola.com to be added to the email list. And also, if you have any questions about I-9, I-9 compliance, audits, etc., then again, you can email proactivehr@ahola.com and they will be able to answer your questions for you. So once again, thank you for joining us today for this webinar. We hope you learned something new about I-9 and the rules surrounding its completion and retention. Have a great rest of your Thursday and have a great rest of your week.